So just a reminder, we will be live on YouTube. If you can keep your microphone muted when you're not speaking, please, that would be helpful.
Good morning. Welcome to this meeting where Hartlepool Borough Council will be hearing evidence concerning an application for a premises licence in respect of the Staincliffe Hotel, The Cliff, Seaton Carew. I'm Councillor Tim Fleming, and can I check that the subcommittee members are happy for me to chair the meeting? Bob? Paddy? Right, I'll just hand over to the Democratic Service Officer to take a roll call of members.
Yes, good morning, members. I'm just going to do a brief roll call. If you could just confirm that you're here, that you have all the paperwork and that you can see and hear everyone. I'll start off with Councillor Fleming.
Yes, no, that was all.
And have you've got all the paperwork, yeah?
I have, yes.
Lovely. Now we have Councillor Buchan, who is subbing for Councillor Loynes. Can you just confirm that for me, please, Councillor Buchan? Are you on mute? Yeah.
I'm off mute now. Yes, I have all the necessary paperwork, which I've read and I can see it here.
Lovely, thank you very much. And we also have here Councillor Brown, who is substituting for Councillor Prince.
Yes, I can confirm that, thanks, Joe. And I also have all the relevant documentation in front of me.
That's lovely, thank you very much. I'm now going to move on to Mrs. Pinkney, who will explain today's process.
Thank you. If I could explain how this morning's meeting will proceed, I will read out the licensing report that has been previously forwarded to you. Following that, each party in turn will explain their representations, why they believe that the licence should be granted or why they have an issue with it. Only the applicant or their representative and those that made representations can speak at today's hearing, and was previously been advised that please be aware that this is being screened live on YouTube and that it is also being recorded. In accordance with the Licensing Act Hearing Regulations 2005, this meeting will take place. The form of the discussion will be led by the chair, and cross-examination will not be permitted. If you want to ask questions of somebody, and then you need to ask the chair, who will decide if it's appropriate. As such, can you please ensure that when it's your time to speak, you provide as much information as possible, and you will be given an opportunity to sum up at the end. When you have finished speaking, one or more members of the licensing subcommittee may ask you questions. Once all parties have submitted their evidence and have summed up, the licensing subcommittee will make its determination and notify all parties within the next 5 working days. You will not be notified of the subcommittee's decision today. I believe that the following people are taking part in today's hearing, and their evidence will be heard in the following order. I will go through the report. We will then move on to Amanda Fletcher and her legal representative, Andrew Tate. And Amanda Fletcher is the applicant. Next, move on to Jane Kett, who is the Environmental Health Manager for Commercial Services. Then to Adrian Hurst, who's the Environmental Health Manager for Environmental Protection. Rachel Reedman, who's the Acting Trading Standards and Licensing Manager. And Ian Harrison, who's the Acting Community Safety Operations Manager. We then move on to Edward Crawley and Judith Godfrey, acting as spokesperson for the residents who have submitted representations. And finally, to advise you that this is Hartlepool Borough Council's first ever remote licensing subcommittee hearing, and I would ask for you to bear with us in case there are any technical issues or hold-ups throughout the way. Can I just check that there are no questions for anybody before I move on to presenting the report? Okay. Okay, this is an application for a new premises licence in relation to the Staincliffe Hotel, Seaton Carew. The applicant is Amanda Jane Fletcher, and the applicant has applied for a licence for the following activities: boxing and wrestling on Monday to Saturday from 11 AM until 11 PM, live music on Sunday to Thursday from 11 AM to 11 PM, and on Friday and Saturday from 11 AM to 11:30 PM. Recorded music, performances of dance and anything similar from Monday to Thursday from 11 a.m. until 11 p.m. and on Friday and Saturday from 11 a.m. until midnight. And the supply of alcohol on Monday to Thursday from 11 a.m. until 11 p.m. and on Friday and Saturday from 11 a.m. until 11:30 p.m. A copy of the application is attached in Appendix 1 to the report, and it's also in Appendix 1A has a typed version of page 17 of the application, just to make it clear for everybody to read. A map of the area is attached in Appendix 2, and a street view image of the premises are attached in Appendix 3 to the report. The Staincliffe Hotel was granted a premises licence for a limited period of 12 months following a licensing hearing on the 27th of June 2019, a copy of which is attached in Appendix 4 to the report. As the licence expired on the 26th of June 2020, a new licence is required to allow licensable activities to be carried on at the premises. The background is that the application has been advertised in the prescribed manner, and 5 representations have been received from responsible authorities. These are attached in Appendices 5 to 9 of the report. And also a letter of objection signed by 11 residents of Cliff Court is attached in Appendix 10 to the report. By way of a summary of the representations received, refer to the applicant's failure to comply with certain conditions applied to the previous licence, and the carrying on of activities that have resulted in nuisance for local residents. Specifically, Condition 2 of Annex 3 of the previous licence requires Mr Fletcher to fully comply with a work action plan relating to fire safety at the premises. The fire brigade has reported that the condition was not fully satisfied and has requested that if a new licence is granted, that the same condition should be added again. Condition 5 of Annex 3 of the previous licence requires Ms Fletcher to arrange regular meetings between herself, responsible authorities and local residents. This condition was added to the previous licence with Ms Fletcher's agreement as part of the negotiations to ensure that the licence was granted. The first of these meetings was required in September 2019, but only took place on the 14th of October, following a reminder to Ms Fletcher from the licensing manager on the 27th of September. At this meeting, only residents from one local address was present, and the residents from Cliff Court who should have been invited have stated in their representation they had not been invited. No invitations to any further meetings were sent to either the responsible authorities or to residents. The representation from Hartlepool Borough Council's Environmental Health Manager in Appendix 5 refers to the applicant's failure to manage waste, rubbish in this case, correctly at the premises, resulting in the service of 2 abatement notices under the Environmental Protection Act 1990 in order to prevent the nuisance from the premises. Appendix 11 details conditions that have been agreed between Cleveland Police and the applicant, and these would be added to the licence should it be granted. Members will note that whilst a number of responsible authorities have stated that, in their opinion, it would not be appropriate to grant the licence, they have nevertheless put forward conditions that they believe should be added to the licence if one is indeed granted. As relevant representations have been received, a hearing must be held for members to consider the application. As the premises licence granted to the Staincliffe Hotel on the 27th of June 2019 was limited to only 12 months, the licence has now expired, and as such a new licence is required in order for the premises to continue to offer licensable activities. A number of those who have submitted representations have highlighted the applicant's failure to comply with some of the conditions attached to the licence which was granted last year. Although the applicant has applied for entertainments to extend as late as midnight on some days, the subcommittee is reminded that by virtue of the Live Music Act 2012 and the Deregulation Act 2015, only entertainments that go beyond 11:30 p.m. Is licensable, and as such, no license is actually needed for any entertainment taking place until 11 p.m. No license conditions can be attached to any entertainment that takes place before 11 p.m. Having regard to the representations received, members may take any of the following steps for the promotion of the licensing objectives: to approve the application in its entirety, to approve the application in part, with or without the addition of further conditions, or to reject the whole or part of the application. Members are reminded that they may only consider those aspects of the licence application that are relevant to the representations received. The recommendation is that members consider the representations made by the applicant and the objectors and determine what aspects, if any, of the application should be granted, and if appropriate, what conditions, if any, should be attached. Thank you.
Thank you, Mrs. Pinkney. I'll now ask members of the subcommittee if they have any questions for Mrs. Pinkney. None from Bob, none from Paddy. And we move on now to the applicant or the representative to present their application to the subcommittee.
Good morning to the subcommittee. These are indeed unusual times. You can hear me in voice, but I don't think, regrettably, you can see me. I'll give you a brief introduction. My name is Andrew Tate. I'm a solicitor working with DMA Law, and I present legal submissions or submissions on behalf of the applicant in relation to this application made under the Licensing Act 2003. I'm grateful to Councillors Fleming, Bucking and Brown for indicating that you've received the bundle, and I hope that you've read with interest the written submissions which took some time to produce and have been produced in advance of the hearing, so that you have a full flavour of the response that will be given by the applicant. I make these submissions on her behalf and indicate at the conclusion of my representations, of course, I'll deal with any questions, and then it will be my position that I'll call the applicant, Miss Fletcher, to provide some information to yourselves. In terms of this application, it's made under the Licensing Act of 2003 by Miss Fletcher and in respect of the Staincliffe Hotel premises. Since it was built in 1869 by a wealthy Hartlepool merchant, Thomas Walker, the Staincliffe has had many reincarnations, becoming a hotel for the first time in 1929. And it, like the area in which it sits, has gone through both good times and perhaps not so good times. At one time, the hotel stood alone, but in hard times, the tennis courts and land adjacent to the hotel have been sold off to developers and then to residents, some of whom now live as close as 2 car lengths to the rear of the hotel premises. And the future of the Staincliffe Hotel itself depends to a very great extent on today's application. I hope that the subcommittee will have seen as Appendix AF4 of Miss Fletcher's statement a copy of correspondence that has been received from Geffen Limited. Geffen Limited hold the mortgage on the Staincliffe Hotel, and the premises have been on the open market with Christie & Co, an estate agents, for some 18 months. There has been to date only one interested party, and that is the applicant, Miss Fletcher. A potential deal, of course, in relation to the premises is only viable if that premises has a licence in order to operate. And the applicant makes it plain that her plans are not viable without the granting of a licence from the subcommittee. I ask, perhaps rhetorically, who, for example, would want to book a wedding, celebrate a birthday, or perhaps even watch a football match on television without being able to at least have the opportunity of consuming some form of alcoholic beverage. In the event of this application being unsuccessful, Ms Fletcher's business interests in the premises will cease. And those who raise objections today should bear very much in mind what they are objecting to, and in effect, if they are successful in persuading this subcommittee not to grant a licence, the consequences that may well flow from that. Geffen Limited, in their correspondence, indicate that they would propose to secure the building by way of boarding it up. what might at one time certainly have been considered the jewel in the crown on the cliff at Seaton Carew could, one imagines, become very quickly an eyesore. And of course, those who work in the local authority and have roles within crime prevention or defending people who come before courts will know that the Staincliffe Hotel would likely be rich pickings for thieves, looting its copper and lead with the real prospect of associated antisocial behaviour, including, of course, arson, and it making an ideal location for the homeless to congregate and squat. I don't say that to strike fear into people's hearts, simply to make the point that some decisions have unintended consequences. Of course, there are 20 people who are employed by the Staincliffe Hotel, and they would all be made redundant when at this time jobs in Hartlepool and the north east of England generally are in short supply. And Hartlepool, of course, as a local area, will lose another large venue shortly after the closing of the Grand Hotel, the Mayfair Complex and the Sporting Domes. It is, I'm bound to say, Miss Fletcher's optimistic belief that the failure of other businesses in Hartlepool need not mean that her business is doomed to fail. She believes she can capitalise on the failure of other businesses to promote her own, to operate a safe, secure and friendly venue in Hartlepool in unison with the local residents and other stakeholders who it's hoped will use the hotel's conference and events facilities, or perhaps pop into what they might consider their local for a pint. Miss Fletcher acknowledges that there will be bumps in the road and that her plans won't please everybody, but it's her strong desire to work in harmony with the local authority and local residents to achieve a balance with which everyone is content. What is it then that Miss Fletcher has done since around this time last year when a subcommittee of Hartlepool Borough Council instilled in Miss Fletcher its confidence for her to uphold the objectives of the Licensing Act of 2003? Your fellow committee members heard about Miss Fletcher's plans to restore the hotel to its former glory through the granting of a licence and have enabled considerable progress to be made towards that goal. Miss Fletcher doesn't shy away from the fact that at last year's committee there were significant objections from the fire service and from the police about the building safety and potentials for crime and nuisance that could occur. Happily, the work of Miss Fletcher has meant that there are no such objections this year, and I would submit on her behalf, and you'll hear from her momentarily, that that's a testament to the hard work and efforts of the applicant and her staff. I invite the subcommittee to look, of course, at the objectives of the Licensing Act 2003, and there are 4 key areas, and I'll turn to each in turn. Some I'll address in greater detail than others. The first, of course, is the prevention of crime and disorder. And there is in all the representations that I've seen, and I hope which have been read by those who were present on this meeting, that there's no mention of any representations of crime nor disorder. The stakeholder, of course, most likely to make representations in that regard are the police force. And we've seen that the police force have no issue with the hotel. They don't object to the granting of a licence, and that in fact the police have indicated a string of conditions with which the applicant has previously complied and would continue to comply in the event of a licence being granted. I would submit that this aspect of the Licensing Act has been dutifully promoted and the objectives complied with throughout the tenure of the applicant's stay at the premises. The second obligation imposed upon the applicant is the protection of children from harm. And again, brief comment can be made of this. There's no mention of any children being at risk of harm, let alone any children being harmed. And that is because the applicant has stringent guidance in relation to the Licensing Act. She challenges 25-year-olds and under in terms of drinking. There's no suggestion of any underage drinking, no misuse of drugs, and no gambling taking place within the premises. And again, that aids and assists the applicant in her application for a further licence. In terms of public safety, the representations that are made are by Ms Kett, the Environmental Health Manager, and her only mention of anything to do with public safety is to say, if you are minded to grant a licence, would you impose certain conditions upon it? No naked flames, no explosives or highly flammable substances, and no lasers. I can indicate on behalf of the applicant that she has none of those substances on her premises, no desire to have them, and she would comply dutifully and diligently with those conditions if you were minded to impose them upon granting of a licence. The other representation that can be made in relation to public safety is in relation to the work action plan, and I will touch on that when I talk about the waste and the developments that there have been at the hotel since the granting of the previous licence. But it's fair to say that that plan has been complied with in whole, and I say save for the replacement of 2 fire escapes. Those fire escapes have a combined value of £40,000, and the fire brigade, in connection with the applicant, agreed that they could be removed from the works action plan, subject to the hotel accepting a prohibition that the upper floors rooms that utilised those fire escapes be put out of use until such times as the remedial work was conducted. That has had the effect of reducing the hotel's capacity from 21 rooms to 5. But, and it will be something I'll submit and make submissions on in due course, the cost of replacing the fire escapes only respectfully becomes viable in the event of the premises having a full licence. At this stage, they are operating the premises in line with the fire authorities' obligations and conditions, and there have been no breaches of the terms of those requirements. In terms of the prevention of nuisance, and sorry, I should just perhaps return and touch upon the fact that the fire authority do not object to the granting of this licence. They in fact suggest a condition which is a like condition to the condition imposed earlier. Effectively, that would require the replacement of the fire escapes for the upper floors, and that, of course, the fire brigade acknowledge would be conditional upon the granting of a licence. In other words, it wouldn't be done if the licence weren't granted, because the premises would not be being used. I move on to the final obligation under the Licensing Act, and that, of course, is the prevention of nuisance. And in this area, there are some representations made by residents and council officials, which I do feel need to be addressed. The first representation that you'll consider is, of course, an issue with commercial waste. I will address that one shortly. The other representations, for the sake of completeness and setting them out, Mr Hurst raises issues with the seating area to the front and rear of the premises outside of permissible times, and there have been some concerns raised by the residents and Mr Hurst himself regarding either excessive noise or the opening of doors and windows, which have allowed noise to escape. And returning then to the point about waste, the committee should be aware that the Staincliffe Hotel, of course, hadn't had a fire safety certificate for some years prior to the applicant applying for a licence. And while I wouldn't go as far as to say that the premises was a death trap, it was certainly, at the time that the applicant took over the running of the premises, substandard. And conditions, of course, were imposed by the fire brigade, of which I've already made mention, to bring that building up to the required standard so that it could be safe for all people to use, in line, of course, with the public safety objective of the Licensing Act. Well, that condition required major renovation work. Not the kind that requires you to fill a black sack and put it in one's car and take it to a waste facility, but the kind that would require skips to collect significant volumes of waste from the work that was being conducted. It is, of course, accepted that skips are unsightly and could give rise to a public nuisance. It doesn't perhaps, of course, look favourable to a hotel having a large skip sat outside of its front door or its premises, and one hopes can appreciate the views from all sides that the work should be completed quickly and with the least inconvenience to all parties. Of course, the work had to be undertaken as a result of the clause imposed by the subcommittee, and the waste couldn't be condensed or reduced. I understand, however, that there has been a dialogue with the council about the waste. There have been 2 times, regrettably, when waste abatement notices have been served requiring work to be moved, These, however, have been complied with swiftly, and the council has not had to take any more draconian action or seek a redress from the courts. They have been addressed by the applicant and her staff diligently and willingly. I believe on one occasion the reason for the waste abatement notice was that a skip couldn't be collected. There had been a storm, and on a second incident there was an unavailability of skips during the commencement of the COVID-19 pandemic. It is, of course, disappointing that Ms Kett doesn't tell the committee about the new arrangements for waste management that are in place at the Staincliffe Hotel, because the Staincliffe has employed the council's commercial waste department recently to dispose of all waste, and I understand that this procedure is working without any issues. I highly doubt that anybody will be critical of the council, the services that they provide in waste collection, which are at the very worst good, or that there will be any issue with waste disposal moving forward. And I do invite the subcommittee, of course, not only to consider the recent history of the licensee's behaviour, but also to consider moving forward, are there likely to be any issues, or is it now in a position where the objectives of the Licensing Act can be complied with without further problem? And in my respectful submission, that is the position that it can be adopted here. The waste is cleared, there is a clear waste management strategy, well managed and put in place, and there won't be issues moving forward if you were to grant a licence to the applicant. I move on to the doors, windows and seating areas. The applicant accepts that there will be times when the doors and windows have been opened or people have strayed into the seating area when they shouldn't have. And I'm sure the committee will be aware of the fact that on these occasions they seem to be limited. Based upon the statements of the residents, they seem to be few and far between, and 5 issues are identified by the residents in totality over a period of 365 days. Some of those incidents, of course, are relatively early in the evening and perhaps less likely to cause issue or nuisance than noise or difficulties that are later at night. Ms Fletcher must, of course, comply with having functions which are imposed upon her by law. She's required, of course, to have fire exits which can't be locked or bolted, and smokers, of course, are now not permitted as a result of government legislation passed some years ago to smoke inside or on the premises. These individuals, of course, when highly intoxicated or in high spirits, may occasionally open doors or windows against the advice of Miss Fletcher and her staff, and they may sneak into the beer garden in order to have a cigarette. And what Miss Fletcher can say about that is this: she and her staff have a strict policy of enforcement. They do regular checks and close doors and windows that they find open. They remove persons from the gardens to the rear of the premises and to the front of the premises who should not be there. And they have adequate mechanical ventilation to prevent the persons within the premises requiring the windows to be opened. It is accepted that on occasion people act outside of the desires of the applicant, but as I say, she believes that her and her staff adequately and appropriately control any difficulties such that the residents in close proximity are not inconvenienced. I move on to deal with the residents' concerns. There is in the statement I've seen from the residents much mention made of events of the 20th of July. There are very different versions of events given by the residents and by Miss Fletcher and her staff, but what appears to be common ground is that the resident on that occasion attended the Staincliffe Hotel to complain of noise. Miss Fletcher was approached and immediately investigated the issue. A door was found to be open, and Miss Fletcher closed that door, apologised for the inconvenience, and told the individual who had attended the premises if there were any further problems to call and ask for her. In my respectful submission, that demonstrates a clear upholding of the Licensing Act's objectives, and in the incident where there was some confrontation, there has been an immediate redress of the position and apology offered. With regard to the residents' concerns about boxing and wrestling, I submit this: there are no interests from the Staincliffe Hotel to hold or have mixed martial arts or MMA bouts within the hotel, and I know that seems to be of concern to the residents about the individuals that they may attract, or about sounds or noises that may come from the premises. So I make it plain at this stage there is no plan to hold any of those bouts, nor are there any plans to hold any wrestling within the premises. The application to extend the licence to allow boxing and wrestling is made because the hotel has a happy history with the Amateur Boxing Association of holding junior fights, which I understand it held for some years before other complexes perhaps sought those contracts or sought to hold those bouts. The closure of other venues in the local area perhaps leads to an opportunity, a business opportunity for the applicants to hold those bouts, and they would largely be family events, junior and amateur bouts. No betting would take place because it is prevented by the Amateur Boxing Association, and of course is not permitted by the Licensing Act, and those obligations would be upheld in the event that any licence were to be granted in that regard. I note as well that there is suggestion that boxing might be shown at what perhaps colloquially is suggested to be local times. I assume that this is with reference to some of these large super fights that have been taking place in Las Vegas, some of which have involved British fighters in recent times, but the residents should be reassured that those fights seem to take place on Las Vegas time between 3 and 6 a.m. in the morning, and of course the hotel would be closed. It would not be operating any viewing of those fights within the premises. And so any figures that there are in that regard, I hope are allayed. With regard the suggestion that sections H and E of the form, that's the application form lodged by Ms Fletcher, are drafted with a view to circumventing or deliberately evading the opening hours or the hours in which the live entertainment can be heard or used, the applicant, through me, makes it clear that that is not the case. We thank the residents for bringing it to the attention, and we clarify the position. The position is this: that bands, singers, and what might be termed live entertainment, such as karaoke, would be played, if the licence were to be granted, of course, until or just before last orders at the bar. Thereafter, background music would be played, and it would solely be background music until closing time. So it's not a case that this is some sort of deliberate attempt to circumvent the Licensing Act. It would absolutely be live entertainment for the times shown in Section E, and Section H would simply refer to background music played up until the closing time. In relation to the holding of meetings, it seems that everyone who makes representations today points to the same thing, that meetings haven't been held. And I acknowledge on behalf of the applicant that it was a condition imposed, I think at the request of the police, that local residents, including the fire, the police and local authorities, hold meetings every 2 months, commencing in September of 2019. The applicant accepts that these meetings have not taken place as requested. Firstly, there was a misunderstanding between the applicant, who believed that the meeting could take place up to 2 months after the September of 2019, and so, for example, up to November of 2019, being within 2 months of September. An email, of course, was received, and it's in the bundle that the subcommittee will have read, from Mr Ian Harrison of the Trading Standards and Licensing Department on the 27th of September, pointing out that a meeting hadn't been held at that time, and the applicant thereafter arranged swiftly a meeting which was attended by police, fire, council officials and a single resident. The meeting, I'm bound to say, appeared not to serve a particularly useful purpose, as the resident who did attend indicated that they didn't have any concerns at that time with the running of the business, and upon discussion with them, they actually stated they would prefer to simply contact the hotel if there were any issues, rather than attend at meetings. and upon feedback from this resident, the applicant attended a significant proportion, and I do acknowledge that there were some people not spoken to, but a significant proportion of the addresses in the area engaging with and speaking to the residents. And all residents spoken to, and you will see as an appendix in Ms Fletcher's statement, all residents were in favour of contacting the hotel directly rather than attending meetings, which could of course be held sometime after any issue arises, or cause inconvenience to them because of the date, location or time. With regard to the views of the residents being clearly felt, it's accepted that no meeting was held from that point forward until a meeting was arranged for the March of 2020, but this had to be cancelled in line with government guidance following the outbreak of the COVID-19 pandemic. The fact, I submit, however, that no meeting had been held would be obvious to all residents, to the fire service, to the police authority and to the council departments. Yet no correspondence has been received by the applicant in relation to this, save for the email outlined from Mr Harrison sent when the first meeting didn't take place. And no complaint appears to be received from from any of the parties in relation to this. With reference, of course, to the council's own policies, which they set out in their document regarding licensing, it says the council maintains it will focus on activities that give rise to the most serious risks or where hazards are least well controlled. And while it doesn't reflect favourably on the applicant that meetings have not been held, I submit that there was no risk to anybody, as there are numerous other methods of reporting any issue that arises at a licensed premises. And with the exception of the email sent in September 2019, the council and residents appear to have adopted a consistent and, I would say, proportionate stance of abstaining from comments about this clause until this application for the licence renewal. It is then, perhaps having sat in silence for 12 months, a bizarre stance to take no action, nor any enforcement, but then to suggest it gives rise to a conclusion that those making representations can have little or no confidence in the management as a result of these meetings not being held. The first question I would pose to the subcommittee, and I pose it rhetorically, it is of course always in your discretion as to whether you wish to consider any questions, is what objective of the Licensing Act would that affect? And I turn back to them. Does the not holding of a meeting increase crime or disorder? Well, we know that there hasn't been any, so clearly it doesn't. Does it mean that children are more likely to be harmed? And again, I say it doesn't. Does it increase or decrease the risk to the public? Well, my submission is it doesn't. And in terms of prevention of public nuisance, as you've heard, that residents have many options and avenues in order to report things to the council, who of course are responsible for enforcement of any conditions under the licence. And I ask why people have sat back without comment for 12 months and now feel so strongly about something that they have known throughout hasn't taken place. Of course, the subcommittee, and you will of course be legally advised, will be aware that Section 51 of the Licensing Act 2003 allows a review of a premises licence if they're not complying, and it can be referred back by any resident or member of the council or any other individual. Section 52 allows for the suspension of a licence if it's not being complied with, and Section 160 of the Act allows for the closure of a premises if there are disorders at the premises. And my submission is that none of these steps have been taken simply because nobody has felt any issue has been arrived at as a result of these meetings not being taken place. I submit there's been a complete acquiescing of the position from all parties. However, by way of submission, if the subcommittee were minded to reimpose meetings, there would be a suggestion from the applicant that a condition be phrased effectively in the following terms, that meetings will take place between and the relevant individuals, including the residents, will be specified, and that then there will be 6 dates formally set within the actual conditions of the licence, And those dates might be, for example, the 15th of every other month and a certain time, so that all parties can be under no illusions, firstly of their obligations, secondly of the dates, times and venues of these meetings, and there won't be any difficulties moving forward for anybody should everybody feel they want these meetings to take place. I'm aware that I've addressed you at some significant length. The last point that I would seek to make is in relation to the granting of a temporary licence. The subcommittee have the opportunity under Section 26 of the Licensing Act 2003 to impose a licence on a premises, either effectively without end date, it only coming to an end upon its revocation under Section 52, that's the suspension of the licence, or alternatively for a limited period of time. That, of course, would give some end date or some expiry date to when the licence would need to be reapplied for and renewed. My respectful submission is this. The granting of a temporary licence does nobody, including any of the stakeholders who are present and will address the committee, any favours. And the reason I say that is this. If you imagine being a business investor and coming to the table thinking about investing in the Staincliffe Hotel, for example, spending £40,000 on some fire escapes, you want to know that that investment has a future. And if the licence is granted for a very short period of time, then people will not be as keen to invest as they might be if the licence was effectively in place until or unless something went wrong or there was some issue with the Licensing Act and compliance with it. The applicant submits this. She is complying with the conditions and the Licensing Act, and then if you were to grant her a licence without a time limit, then she would continue to comply with the obligations under the Licensing Act. If any party felt that there were issues, then just as they could with a temporary licence, they could refer the matter back to the subcommittee under Section 51, and the subcommittee could adjudicate on whether the licence should continue to be enforced or not. If one grants a temporary licence, the position is effectively exactly the same. Residents and the council bodies have exactly the same powers to refer the matter back if there is a difficulty under Section 51, but it doesn't provide the same safeguard to the applicant for the investment that she, and I have no doubt the residents and locals to the Staincliffe Hotel would seek in order to secure the investment and the hotel's future moving forward. And of course, we all are aware of the difficulties we labour under in these troubling and unprecedented times. My submission is to give some safety and security to the Staincliffe Hotel by the granting of a full licence would be appropriate in this case. I'll pause there. I don't think I have anything that I would seek to add, but I'll certainly address any questions that the subcommittee might have prior to asking Ms Fletcher to give you an update in relation to the position and provide her statement effectively to the subcommittee. Can I assist anybody further or address anything that arises?
Right, thank you, Andrew, for your submission. Is there any members of the subcommittee who would like to ask any questions of Andrew before we move on to Ms Fletcher? Paddy?
Sorry, thank you, Chair. I think I'm happy to wait to hear what Ms Fletcher has to say before I have any questions.
Right,
Of
thanks
course,
very
I
much.
understand that.
Yeah, we'll move on to questions from Ms Fletcher, if that's all right with you, Andrew.
I think Ms Fletcher's going to firstly provide perhaps some input herself, and then if questions could follow thereafter to either me or Ms Fletcher, would that be appropriate for the subcommittee?
Yeah, that's fine.
Thank you. Well, I'll defer to Ms Fletcher then.
Thanks very much.
Good morning, everybody. I believe Andrew has hit most of the points that I'd like to go over. I'd like to answer any questions if anybody has any for me.
Right, thank you. Yeah, I've got one for you, Tim Fleming. Why do you think the licence that was granted last year was limited to just 12 months? Because I can't remember the council having issued a time
I
limit
think
before.
that mainly boiled down to the local authorities. There was a lot of work to be done with the fire and the police, but every bit of work that we've been asked to do has been completed. There's been no objections for any of the authorities. It seems like the only reason for this meeting is down to the meeting of the residents, which I can only apologise for and set something in stone in moving forward, where everyone is aware of dates and meetings that are going to take place.
Right, thanks very much. Anybody else got any questions? Right, Paddy.
Thank you, Chair. Yeah, thank you, Mrs. Fletcher. Obviously, the monthly meetings were a great part of that. I guess in demonstrating that you were of sound and fit and proper to have that license. Did you not understand that?
I did, but going from the feedback from the first meeting, it seemed like the residents weren't interested or able to come at that specific date and time. When we held the first meeting, there was only actually one resident that turned up, and having to speak to the local residents, the majority of people say if they have any issue, they will come direct to ourselves and deal with it that way.
If I can just come back to that, Chair.
Yeah.
I do appreciate your answer there, but I mean there was a reason why that condition was imposed, and it was there to ensure that there was always a line of communication between the applicant and the resident and the responsible authority. And it seems that communication broke down largely of a decision of yourself.
I think that in moving forward, if there was specific times and dates that everyone was aware of well in advance rather than trying to hold them with a significant amount of time, then everybody who wanted to participate and that would have enough notice to be able to attend those meetings.
Can I just address that point as well, please? Just to say, I think that there has been a breakdown of communications, but I think that that's been on both sides. This isn't a case that there have been regular and frequent reminders or people taking significant issue with it. And while, of course, one has to acknowledge that the licensee is Miss Fletcher, there are other people who could have brought this to the attention of the council, Miss Fletcher, or other bodies much sooner. And of course, that may have meant that the conditions were reimposed and these meetings were attended. But I hope that the proposal that Miss Fletcher makes of making it abundantly clear that she would, first of all, hold these meetings, but setting specific times and dates within the body of the annex of the licence would mean that everybody from this meeting moving forward, and I'm bound to say that the people who have representations to make and the strongest views will of course be present either on Zoom or Skype or on this telephone call, and they will know moving forward the times to attend, the representations that they can make, and their obligations to be there if they want to make any points or feelings felt.
Chair, may I speak? It's Judith Godfrey.
Yes, yeah.
Just a quick question. As residents of Cliff Court, I note the list of people that Amanda contacted. There were none of the residents for Cliff Court, yet we were the ones who you are saying are the ones who complained and were objectors last time. And it seems strange that none of us were contacted to be invited to the meeting in October, nor were we contacted by when you came round the doors. None of our names or addresses appear on that list, yet we are the people that we would have thought would have been first on your list. And as lay people, we weren't aware that it was up to us to push you to hold the meetings or to push the local authority. And we would be happy if the meetings were set in stone going forward, should another licence be granted.
Right, thanks, Ms. Goffin. Paddy, in relation to your question, have you got anything else to put into it, or is that the finish of it?
I would like to add something, if that's okay. As the spokesperson for the residents, if I could have direct contact details, as I'm not sure everybody is aware, but it's very hard to actually gain access into Cliff Court. It has to be through a speaker system. So if I had a direct contact number for a spokesperson, I could go direct to them and there would be no issues with making them aware of the meetings.
The access to...
Right.
Sorry.
Yeah, if you just hang on, please. We'll sort that out in a bit. We'll just finish off with Paddy's question, and then we'll move on, because we do have a procedure to follow. And I can see where both of you come from, but it's something we can iron out later in the discussion. So thanks very much. I'll just go back to Paddy.
Thank you, Tim. Yeah. I mean, I do find it disappointing. I've listened to the answers of Miss Fletcher and indeed her legal representation, suggesting that there was responsibility on both parts. But the license clearly stated that the meetings should be held, and they weren't. And we must look to who was responsible for that. As the resident just highlighted there, they weren't invited to any meetings. The meetings didn't happen, and they should have. Thank you, Chair.
Yeah, thanks very much then. Right, we'll move on. Is there any more questions from the subcommittee? No? Right, thanks very much. We're now going to move on for reports that are submitted by representatives regarding the application, and they'll begin with Mrs. Kett, followed by Mr. Hurst, Mrs. Redmond, and then Mr. Harrison. So if we go to Mrs. Kett first, please.
So, sorry, Chair, to interrupt. I did put my hand up on this.
All right, it didn't come up.
Sorry. I'm just wondering whether it'd be appropriate to just have a short break before we get into the second part of the meeting.
Yeah, we could have a short break now, if that's okay with everybody. Paddy, yeah? All right then.
Yes, Chair,
You
I'm
could have a
happy with
short
that.
break for a few minutes, and then we'll get back online. Thanks very much.
Thank you, Chair.
Right.
Thank you, Chair.
Just to advise, Chair, we'll need a couple of minutes to stop this. If everyone could just wait.
Ed saying we are now streaming. Tim, your microphone's muted. You okay to restart, Chair?
I'm not sure it's ready.
Right, welcome back, everyone. We've had a few technical difficulties. I'd like to apologise for that. Before we carry on, I'd like to just apologise to Mr. Crowley. He put his hand up before we finished, but we can go through what he has to say when it comes to his questions, which is after this lot now. So we'll go now to Mrs. Kett to present her report, please.
Thank you, Chair. I'm Jane Kett. I'm Environmental Health Manager for Commercial Services at Hartlepool Borough Council. I submitted a written representation in respect of the application for a premises licence in relation to the Staincliffe Hotel. The reason for my representations are outlined in my written submission. With regards to the failure to manage commercial waste at the premises, I would like to explain that the Council's Public Protection Division operates a graduated approach to enforcement. This involves initially the provision of advice and guidance, and this can be provided both verbally and in writing. And where necessary, enforcement action may be taken, and this would result either in the service of an enforcement notice or ultimately prosecution if non-compliance persisted. There have been several complaints concerning the applicant's failure to manage commercial waste. The first complaint was notified to the department in September 2019, and this was notified by the Fire Authority. It was reported that there was a large amount of rubbish in an open skip to the side of the Staincliffe Hotel. An officer visited the premises to investigate this matter and spoke to the applicant, who explained that a new company was operating the business. It was ascertained that they did not have a commercial trade waste agreement in place. What this meant was they did not have any specific arrangements for the disposal of kitchen waste and waste oil. Photographs were taken and the applicant was advised to remove the waste. A revisit was also agreed whereby the officer would return to check the removal of the waste. Several days later, the revisit was undertaken and there was no change noted. At that time, the applicant was not present and a member of staff was spoken to. It was explained that the officer was of the opinion that the accumulation of rubbish, which was an open skip and a large quantity of black refuse sacks to the side of the skip, constituted a statutory nuisance. A statutory nuisance can include accumulations or deposits on premises of waste, for example, piles of rotten rubbish. For an issue to count as a statutory nuisance, it must do one of the following. It must either unreasonably and substantially interfere with the use or enjoyment of a home or other premises, or injure health or be likely to injure health. Person served with a notice must stop the activity or take specific actions, such as to remove the rubbish. If someone does not comply with an abatement notice, they can be prosecuted and fined. Further visit was made, and again, no further change was noted. Consequently, an abatement notice was served in respect of a statutory nuisance. The applicant was given 7 days to remove the rubbish and also required to prevent its recurrence. The notice was served in respect of a statutory nuisance because there was food waste present, and also packaging materials were also noted to be present in the skip and the adjoining area. It was not served in respect of building waste. It was explained at the time that the use of an open skip was not acceptable for use to dispose of commercial food waste, as it would attract vermin and other pests. It is correct that that notice was complied with. At a later date, the company was visited in connection with a food hygiene inspection and again reminded that a commercial trade waste contract was required and the use of open skips was not acceptable. Sometime later, in April 2020, a further complaint was received. This time it was received from a member of the public. It was reported that there was a large accumulation of hundreds of black bags and an overflowing skip to the side of the premises. It was alleged that it had been there for months behind double gates. It was also alleged that it was causing a rodent infestation. The officer visited the site and confirmed there was indeed an open skip at the side of the premises and many overflowing black bags to the side of the premises. Again, food waste, packaging, bottles, broken eggshells were noted to be present. Consequently, on the 21st of April, a second abatement notice was served. This time, the applicant was given 28 days to comply due to anticipated difficulties in getting a skip contractor during the COVID pandemic. 3 days later, the officer received a telephone call advising that the premises was in the process of getting the rubbish cleared. The first skip had been removed and a second provided. This was due to be collected a few days later and a third delivered. The business had also arranged for a trade waste contract to be entered into. 3 weeks later, the skip was still at the premises containing rubbish. The area around the skip was clear. Inquiries ascertained that the trade waste agreement had been received by the council, but had not yet started as no payment details had been received. The notice was due to expire the following day. The business was spoken to and it was explained that they were waiting for the delivery of trade bins before the skip was actually removed. The business was reminded that enforcement action would be taken if the notice was not complied with. The skip was removed and a trade waste agreement was set up. If either of the notices had not been complied with, enforcement action would have followed and this would have resulted in a prosecution and, if found guilty, obviously a fine. Whilst the applicant and her solicitor has suggested that the issue with regards to removal of the disposal of building waste was only short term, this was not actually the case. The reason for the 2 abatement notices was because of the food waste and other putrescible waste being present rather than building waste. No trade waste agreement was in place initially and right up until the time of the second notice coming to an end. This is the primary reason that I've actually explained that I had little confidence in the current management of the premises. I personally have worked for the authority for in excess of 30 years, and I've never known it be necessary to serve 2 abatement notices on a commercial food premises or a hotel. It is a legal requirement for a food business to have adequate arrangements in place for the disposal of food waste and waste oil. The business must maintain a trade waste agreement and the use of an open skip is unacceptable. If the licensing committee is minded to grant a licence, in my submission I did suggest a number of conditions which should be applied to promote the public licence objective. I also can confirm that I've never been invited to a meeting with the applicant or residents or fellow responsible authorities. That is my representation, Chair, but I'm very happy to answer any questions.
Yeah, we'll come to the questions at the end. We're going to go through the representations of the other people on the thing as well. So we'll go to Mr. Hurst next. Thanks very much, Mr. Kett.
Thank you, Chair. My name is Adrian Hurst. I'm the Environmental Health Manager for the Environmental Protection Team and Public Protection at Hartlepool Borough Council. My representations revolve around the prevention of a public nuisance objective. I wish to object to the issue of this licence on the grounds of that I have no confidence in the management in their ability to promote the objectives of the Licensing Act. The reason I say this is the first one is the meetings that have been mentioned by a number of people. There's a condition requiring that they hold a meeting every 2 months. As a responsible officer of the local authority, I have only ever been invited to one meeting, which was held on the evening of the 14th of October 2019. This meeting was only convened following a reminder to the licensee from the licensing team at Hartlepool Borough Council. Considering the considerable attendance and interest at the earlier review hearing that I was involved in, I was surprised that only 2 residents turned up to this meeting. I am not aware that any further meetings have taken place. I would like to refer to conditions 4 and conditions 13 in Annex 3 and Annex 2 of the application in the report. Condition 4 of the licence states access to seating areas to the front and rear of the premises should be restricted to between 9 AM and 8 PM April to September and 9 AM to 5 PM October to March. Condition 13 states that all external doors and windows to parts of the premises used for the purpose of regulated entertainment are not to be left open whilst entertainments are being held in the premises, except in the case of an emergency. Up until the national lockdown and the closure of all licensed premises in March 2020, following the coronavirus pandemic, the Environment Protection Team was still receiving complaints and allegations that both these conditions were being regularly breached and that the situation at the Staincliffe had not improved since the review hearing the year before. Arrangements had been put in place to carry out monitoring, but due to the coronavirus lockdown, these had to be cancelled. They're my representations, Chair.
Right, thanks very much, Mr. Hurst. We now move on now to the representation from Mrs. Redmond.
Rachel, can you move your microphone down so that it's actually in front of you?
I don't have one.
All right, it's just you're very, very faint.
Sorry, I'll speak up, thank you. I'm Rachel Redmond, acting City Standards and Licensing Manager. I haven't got anything to add to the standards presentation, but I'm happy to answer any questions you may have in this part. Thank you, Chair.
Thank you, Mr. Redmond. We now move on to Mr. Harrison, please, for your report.
Yes, thank you, Chair. I've just made a few notes to go in addition to my written submission. Firstly, referring to the applicant's written submission, paragraph 5, the applicant states that by granting the licence in 2019, the subcommittee must have had confidence in the applicant. I would say that this is not reflected in their decision to grant a licence for only 1 year. In relation to paragraph 21 of the submission, this states that the meeting that took place in October appeared to serve no useful purpose. With respect, Chair, this is a legally binding condition and is not something that the applicant could choose to comply with, whether or not she considered that it served a useful purpose. Paragraph 23. Despite the applicant apparently feeling that the meeting served no purpose and accepting that she arranged no further meetings, for some reason the applicant states that they then attempted to arrange but then had to cancel a meeting in March, cancelled because of COVID. As licensing manager, I was not aware, nor were my staff aware, nor were any of the responsible authorities that I've spoken to aware of such a meeting being either arranged or cancelled. I note in the Fire Brigade's written representation, they say that whilst officers of the Fire Brigade would participate in meetings with local residents, the police and local authority, I am instructed that this condition has not been strictly adhered to. The applicant will therefore need to explain the apparent deficiencies in the holding of meetings on a regular basis. I would also say in relation to paragraph 28, in relation to actions taken by the licensing authority, the applicant states it is perhaps a bizarre stance to take no action by way of reminder. I would remind the subcommittee that a reminder was sent to Ms. Fletcher in September 2019, and this is indeed accepted and referred to by the applicant in their own submission. I would also suggest that it is not for responsible authorities to have to constantly remind licensees of their legal obligations. In respect to Amanda Fletcher's personal statement, paragraph 15, Ms. Fletcher takes it on herself to assume that no further meetings were required with the residents and responsible authorities. She states that she spoke to the police and fire service in coming to this decision. As most of the objections in 2019 related to noise, it is unfortunate that she did not consider the views of the Council's Environmental Health Department or Licensing Department when coming to this decision. There was one other matter I wanted to refer to, and that was the exhibit AF3 that Miss Fletcher produced. And this was a statement regarding an alleged incident that happened on the 20th of July. And it was really just to draw members' attention to the statement is actually dated the 21st of July. So the incident happened on the 20th, and this is a statement dated the 21st of July, but it's actually dated the 21st of July 2020, referring to the incident that happened on the 20th of July 2020. So I would just bring that to members' attention, as it appears it wasn't written on the 21st of July. Chair, that is all I have to say on the matter at this present time, but I may sum up at the end.
All right, thanks very much, Mr. Harrison. Right, I could ask members of the subcommittee if they have any questions of any of the people that's just been on. None from Paddy. Bob? You're not coming on, Bob? No, Mike?
That should be on now.
Ah, you're on now, yeah.
Yes, just for Jane. Is adequate waste disposal contract now actually valid? And are they actually using it? Have there been any more problems since they took the contract on?
I'm not aware of any recent problems. As far as I understand, obviously the contract was taken out, and it really was taken out just as we were starting in the COVID period, and the hotel has not been operating during that time, to my knowledge. So no, there haven't been any problems that I'm aware of. As I say, we did confirm that the waste agreement was now in place. But we haven't really had experience of the business actually operating as a commercial premises, or certainly the food aspect of the business operating.
If I could just add something to that.
Hang on. This is for members only to ask questions so they can get a fuller picture from the reports.
No problem. Sorry about that.
Right. Any more, Bob?
No, that's it. Thanks, Tim.
Anything else from you? No? Right, we'll move on now to the Mrs. Godfrey and Mr. Crowley to make their representations. I don't know which one's coming first.
Yeah, go on.
Hello, my name's Judith Godfrey. I'm going to speak on behalf of myself and Edward Crawley and the residents of Cliff Court. I have written down a statement I'd just like to read out to you, if that's okay. It's disappointing that the neighbours of the Staincliffe Hotel have found themselves in the position of objecting again to the licensing request submitted by the Staincliffe Hotel. After the long discussion and agreements reached last year, it was hoped that a thriving business would have developed, the property would have been purchased, as was mentioned last year at the licensing meeting, the necessary refurbishments and repairs carried out, and the terms of the licence would have been adhered to. Therefore, it would have been a formality for the committee to have issued either a further temporary or permanent licence this year. Unfortunately, the Staincliffe Hotel has failed on numerous occasions to ensure that noise levels were kept to an acceptable level, i.e. doors and windows were kept closed and customers were not allowed to the gardens after the times agreed. This would have saved the number of public nuisance complaints regarding noise levels. We accept that there will be an element of noise when events take place, but not to the extent which has been the case. This has been due to a failure to manage the supervision of the rooms, ensuring that doors and windows remain closed during events as stated in Section D of the application. There seems to be no mention of the use of the outdoor spaces in the new application. Also, the Staincliffe failed to meet its obligation to call regular meetings with their neighbours to discuss any issues, compliments or complaints. Only one meeting was called, and they failed to invite the residents of Cliff Court entirely, and they were not canvassed after that meeting for our views. It is our view that to give extended times of operations over and above the 2019 licence and to add boxing and wrestling to the mix is unacceptable. Any licence should be as per the 2019 licence with the same conditions attached until it is shown that the terms of the licence can be adhered to by the management team at the Staincliffe Hotel. We are not NIMBYs, but wish for us to coexist in a respectful, neighbourly manner and to feel that if any matters are brought to the attention of the licensee, they are dealt with in a courteous manner on both sides. We appreciate the work that the licensing and environmental team do. However, we are aware that it is difficult to contact them at weekends and evenings when most of the issues take place. And we appreciate this is probably due to a lack of resources, but we thank them for their work on our behalf. That's all. Thank you.
Right, thanks, Mrs. Godfrey. Is there anything else to be said, Mr. Crowley? Sorry.
Yes, I'd like to make a comment about the noise issue. Amanda has said that she's done a local poll of the local houses that are adjacent to the hotel. Out of the 11 addresses that she's actually noted, one of the 18, it's actually 18 houses that she's done a poll, or she said she has. One of the 18 is a house that is in fact being renovated, and the name noted is the actual builder of the who is actually working in the house. One of them made no comment at all. That's number 2, the Cliff. One is, in actual fact, the Amanda Fletcher's registered office business address. That is number 5. The other properties on the Cliff are in front of the hotel, so therefore much less likely to be annoyed by noise. She has actually made only 3 polls of houses which are at the side of the hotel, and they actually 2 of them are at 84 metres from the hotel, and the other is 63 metres from the hotel. Whereas Cliff Court, on the average distances, is only 15 metres. So you can appreciate that Cliff Court is a much closer than anywhere else that Amanda has asked if there's any noise nuisance. That's it. Thank you.
Right, thank you, Mr. Crowley. Right, I'll ask members if they've got any questions of Miss Godfrey or Mr. Crowley. None from
Nothing
Bob?
from me, Tim.
No from Paddy. Right. Before the applicant is asked to sum up the case, do any of those who made representations against the applicant have anything to say by way of summing up? Ms. Kettner? Mr. Harrison? Are you coming on in?
Yes, I am. Thank you, Chair. It was really just a couple of sentences, really. Last year, a 1-year licence was granted to allow Ms Fletcher the opportunity to demonstrate that she could comply with the licence, including its conditions. I was there at the time, and the condition relating to regular meetings was specifically designed to ensure that there was a regular dialogue during the temporary licence period, so that any issues could be addressed quickly and that the licence could be made permanent in 2020 without objection. That was the reason for that condition. It was to make it easier for the licence to be granted when it needed to be renewed. Partly the fact that we're here today is because those meetings didn't take place, which didn't allow for issues to get resolved in a timely fashion. As Ms Fletcher deliberately chose not to comply with that condition and allowed others that were designed to reduce noise nuisance for her neighbours to be broken, I would simply say that Ms Fletcher has not used the year she was given well. I would therefore argue that in such circumstances, and with that in mind, converting a temporary licence into a permanent one would not be a promotion of the Act's licensing objectives. Thank you, Chair.
Thanks, Mr. Allison. Has anybody else got anything to say, Adrian? I'll come back to you, Paddy, because it's representatives at the moment. Adrian, have you got anything to put through on your summary?
No, Chair, I think I've said everything I want to say. Thank you.
Ms. Redmond?
No, thank you.
All right. What is it you want to say, Paddy?
Thank you, Chair. Yeah, it was just a bit of a summary from listening to this meeting, and you know we've heard how that meetings didn't take place, the waste wasn't controlled, the noise wasn't addressed, the nuisance through waste, the doors and windows, the management of that wasn't addressed, and it just seems to me like there's been no responsibility or respect at all given to this license. You know, I mean, it is an iconic building, and I would hate to see it close, but I think we do need a better display of what's been going on.
Right, thanks, Paddy. I'll just bring in Mr. McNabb.
It's okay, Chair. It doesn't matter now. All I was going to say is that really, once we go into private discussion, that's when those sort of comments should be made. It's really questions at the moment.
Right, yeah. Right, we now go to the applicant and see if they'd like to sum up their application, please. Are you there, Andrew?
Hello, Chair. Can you hear me?
Yes, yeah, got you now, loud and clear.
Excellent. Well, I think we can all agree with the comments that was perhaps made by your committee member when he indicated that this is an iconic business and we would all hope that it could continue. I think everybody on this call would agree that if the Staincliffe Hotel can be run in accordance with the requirements under the Licensing Act 2003, that it will bring about a great benefit for the residents, for the local area and for the Hartlepool and Seaton Carew area more generally. I acknowledge some of the things, and it's difficult to hear, being somebody who represents the applicant, about difficulties or perceived or failings that have allegedly taken place. And what I can say on behalf of the applicant is I've certainly heard those loud and clear, and I know that she has. And it seems like while much work, I think people would say, has been done, there are still areas which potentially require addressing. And I would hope that, bearing in mind the alternative, which I suspect that the residents and the local authority would not want to say, that if the committee were minded to take the view that a licence could be granted, then certainly conditions could be put in place, such as those that I've proposed, and I'm more than happy to speak to individuals about proposing such that the business could continue. And I think it was Miss Godfrey who, some of the comments she made were particularly pertinent about wanting to live and coexist with the business. They are pro-social views, and ones that I can only commend to the committee and to the applicant, that this is really a position where everybody wants both the businesses and the residents to lead a happy coexistence, and ultimately for the business to flourish and bring with it the jobs and services that it provides. And I acknowledge her concern at the fact that she certainly hadn't been invited to meetings. I know the applicant's mindful of those concerns, and that's why I proposed early in the meeting a potential condition to say, look, these conditions can include a meeting. It can be specified at the outset the date of those meetings. The venue, of course, can be the Staincliffe Hotel, and the time, so that it's easy for all stakeholders to attend and to provide their views. And hopefully, in the coming months, and you've heard about things like the waste disposal, there is now a waste management policy in force. It's being controlled by the council. I acknowledge that owing to COVID, there hasn't been the opportunity to really properly, rigorously test that, owing to the hotel effectively being closed. But nonetheless, when it opens back up, we know that the correct procedures in force, We know that the council do a good job in clearing the waste, and we know, I've spoken to the applicant, the direct debit's been taken recently, and those issues will be addressed. If there are concerns about noise, specifically to the residents to the rear of the Staincliffe Hotel, and I do note that it appears to be the residents to the rear of the hotel that seem to have the difficulties, insofar as residents at the cliff don't seem to necessarily be objecting today or have issues with the noise. If that is the case, then certainly conditions can be put in place, and they're suggested within the council's licensing document about, for example, imposing conditions to keep doors, windows closed, to provide further suitable mechanical ventilation, to reduce, for example, sounds by installing a suitable noise limiting device, which would be calibrated and approved to a level in conjunction with council officers to prevent sound exceeding an appropriate level. And it's my respectful submission that measures such as that in condition form can allow the hotel both to continue operating, but also for it to live in harmony with those residents of Cliff Court who, I understand from their submissions, feel like they've been left in the dark a little about what's been going on. But I would echo from my submission earlier that largely the requirements of the Licensing Act have been complied with, and it does appear that they, if one was to say the more minor, and I don't do that to reduce the impact or the meaning of the Act, but this isn't that there's been wide-scale partying or antisocial disorder. There appears to have been a lack of holding meetings, and I would invite you to consider that in the context. I acknowledge it's effectively a breach, but I would invite you to consider that in the context of the good work that's being done, a lack of crime, a lack of antisocial behaviour order, no vandalism, and the like when considering the appropriateness of granting this licence. I think I've said all that probably can be said at this stage. I do note the suggestion that a temporary licence be granted if one was to be granted, but I do echo the submission that I made earlier that a temporary licence doesn't necessarily provide for the investment, and it has exactly the same ability to be challenged and enforced by the council should anybody have any, or any other person, should anybody have any issues with it. And for that matter, I would invite you to accede to the applicant's application to grant her a full licence and impose conditions which can be stipulated either by the subcommittee or agreed by way of agreement, looking at the statements of the objecting parties and those that the subcommittee feel are appropriate. I don't know though whether I can assist any further, but I would answer questions and clarify any points.
Right, thanks very much, Andrew. Right, have all parties said everything they would like to say? Is there anything that anybody would like to bring up? No. Right, thank you. As everyone has now made their representations, I will call this hearing to an end. The subcommittee will now retire to deliberate and make a decision. All parties will be notified of our decision as quickly as possible, but no later than 5 working days from today. Thanks very much for the perseverance of you all. It has been hard going doing it this way, but I do appreciate everything you've done. Thanks very much.